Okay, we're going on to YouTube. And the case we're about to hear is the Carla Alanis Garza Alanis, is that the right name? Versus Arcelia Hernandez, cause number DC 216493. Counsel, make your appearances.
Juan Marquez for the plaintiffs, Your Honor.
Andy Edmondson for defendant Arcelia Hernandez Vasquez, Your Honor.
Okay. All right. Let's go ahead and get started.
Sure. Your Honor, my clients have a contract with a Mr. Jose Hernandez, who is married to Arcelia Hernandez. And it's an oral contract. They paid 10 years on an agreement that they would be able to purchase the property. So Ms. Arcelia Hernandez, who does not dispute that it's community property and who does not claim to be the sole owner of the property, has filed an eviction action. And my clients have been paying faithfully on this. They're up to date on the payments directly to the mortgage company, which is what they've been doing for the last 10 years. So the eviction action will damage their claims to the purchase of the property. And that's the plainest statement that I can make on this.
Okay. Response?
Yes, thank you, Your Honor. I mean, basically, this is a garden variety statute of fraud situation. I don't think I need to enlighten the court too much on that. Obviously, there was an order entered for eviction, and this is basically an effort to, this particular district court case is an effort to, stymie the eviction process. As plaintiffs produced with their filing for today, they included a copy of a lease. So in theory, we have a ongoing month to month for the duration. So they knowingly executed a contract for lease. Subsequently, and upon eviction proceedings, there's a new oral agreement alleged. And quite frankly, there are no writings, there are no signatures. And to me, this just seems like the garden variety situation in which the statute of frauds was designed to preclude.
Looking at the TRO, Mr. Marquez, and I may be missing it. Is there I don't see that you included any type of documentation that showed that your client actually owned this property. Was there any type of writing about this? Was there?
They filed an affidavit, but there is no writings that they depended on Mr. Hernandez to come through on his promise. And Mrs. Hernandez shows up and says that she's the owner, which she is not the full owner. So she cannot claim. And our petition alleges grounds for liability on her part on the basis of agency over 10 years. So we claim that we have the right. Also, the eviction action has been appealed and is on appeal. And we just feel like this is affecting her rights to validate her claims against both defendants.
So this is, I believe, your petition that I'm showing on the screen, Mr. Marquez. Is that right?
Yes, Your Honor. And
the fonts on this are a little strange, so I want to make sure I'm not missing something. So is this the notice? What I'm showing on the screen right now, is that the notice to the tenant? Is that her basically eviction notice?
Yes.
Okay, I see that. And then this is, I assume, the justice of the peace. What, return of service? Is that it?
Yes, Your Honor. And after that is the appeal notice from the court.
So what, you said there was an affidavit attached. Maybe I missed the affidavit. Where's the affidavit?
Let me see.
I could be missing. I just don't see it attached to that.
It
I
would
believe it's. I
Oh, you
believe
maybe, oh, you did an amended petition, it looks like.
Yes.
Okay. All right, so let's see what's in the amended petition. That may be what we're missing here. Okay, here's the affidavit.
Yes, here's the affidavit. On page 12.
Okay. All right, Mr. Edmondson, what's your response?
Yes, Your Honor. I'd like to point out affidavit at paragraphs 7 and 9. Those are basically the only two fact statements that are even relevant to potential ownership or any claim thereon. And it basically just says that they believe they were purchasing the property in paragraph 7, and then paragraph 9 that they have a claim that they have a right to own it. It's devoid of any facts as to how we get there, and we don't have any. There's no writing to base anything upon. So to me, this is just an empty claim. And if we talk about a claim in equity where we're trying to get an extraordinary relief here, there's not only is it not there is no probable right, it seems highly improbable based on one, the statute of frauds, and two, the fact that you don't even have any specificity within their claim or within their affidavit as to how we get to where we're at.
I kind of agree with Mr. Edmondson, but not fully, I guess. Mr. Marquez, he's generally right. This is probably going to be governed by the statute of frauds, but that's an affirmative defense that it is possible to get around in certain circumstances. And so just because you don't have something in writing that isn't necessarily, it's probably going to be dispositive, but not necessarily. But the way this is written, it doesn't show us why they believe they were it doesn't give us like, okay, we entered into an agreement and blah, blah. It doesn't describe anything about what the agreement is and why they thought they were purchasing it. And so I do think this particular, this particular affidavit is probably insufficient to stop the eviction because it doesn't give us enough information about why they believe they're owners.
And Your Honor, if I may step in one more moment, at this point, we're really dealing with possession. They do have an appeal pending, so as far as eviction goes and the immediacy of that, I just don't see it. The case needs to be, the appeal needs to be consolidated, would be my guess here. And I'm sure we can work that out. But as far as just, immediate harm, it's just not there.
What do you mean it needs to be consolidated? Consolidated with what?
Well, we'd probably dismiss the appeal and agree to this, something like that. There's just two pending cases right now because they've appealed the eviction procedure. There's an order to evict. So it's just pending a writ of execution.
I don't know if I agree that if you want to consolidate that case into my case, I would see that. I don't know that you could consolidate our case into their case because they can't deal with issues of title.
Correct.
And there may be issues here involving, the right, if there were improvements, quantum merit. I mean, there's a lot of stuff here. I don't know based on what we have, but
agreed.
But yeah, for now, let's go ahead and I'm going to deny the TRO. But Mr. Marquez, if I agree with Mr. Edmondson. You might want to talk about consolidating the two cases into my court. And you do need to provide greater specificity about why you believe that your clients own the property. Like what exactly was the deal? What led up to it? That kind of stuff. Does that make sense, Mr. Marquez?
Yes, Your Honor.
Okay. Do you have any questions either side?
No, Your Honor.
None, Your Honor.
Okay. All right, guys. You guys be safe. Okay.
Thank you. Have a great week.
You too.
Okay, Andy, give me a call when you're ready.